Good evening, everyone, and thank you for joining. I'm Michael Ettinger from Ettinger Law Firm. And as you can see, this is our webinar, Four Advantages of Using Trusts. I'm the principal of Ettinger Law Firm. You can see our staff in front of you. I hope everybody can hear me. There I am in the center. To my left is my lovely wife and law partner, Suzanne Ettinger, and our other attorneys and support staff, mostly paralegal professionals. Our website is trustlaw.com. You can see there. And our practice is limited to trusts and estates, wills and probate, estate tax savings, Medicaid applications, and Medicaid trusts. We have 12 offices in New York State. In Nassau County, we have two, Lake Success and Rockville Center. 3 offices in Suffolk, Huntington, where I am this evening, Melville and Islandia. Staten Island, we're at 900 South Avenue, the Nicotra Building. Westchester, 140 Grand Street in downtown White Plains. Rockland, we're in New City. And Orange, we're in Crystal Run, right there by the Middletown, by the police barracks, the Westage Center there. Dutchess County, we have offices in Fishkill, and again in the Westage Center, and in Rhinebeck, right in town. And in Albany, we've been there for more than 30 years at 125 Wolf Road. We have about 200 participants tonight, so we have a lot of company. At the bottom, you can, your screen, I understand you can pose questions. We're going to hold the questions to the end. A lot of people sent questions in. I have them here. I'll also answer those at the end. But I won't answer the questions during this seminar because it breaks other people's trains of thoughts. We'll hold all the questions till the end. So thank you for your patience, and I hope you can stay and listen to the question and answer session when we're done. So with that, we're going to get started. Well, if we talk about elder law estate planning, we first have to define it. So elder law estate planning is an area of law which combines the features of elder law, which is disability planning. Very important. In fact, here at Ettinger Law Firm, we like to say planning for disability is more important than planning for death, because planning for disability is for you. Planning for death is for someone else. You come first. So estate planning follows death planning, and we're going to go into these in some detail. But by way of overview, I like to say we use trust to create order out of chaos. And that is because trusts avoid the pitfalls of wills by saving time and money and settling the estate. We're talking significant time and money, as we'll see. Avoid legal guardianship if you become disabled. If you don't have a plan for disability, you risk getting the state's plan. We're going to talk about that and why it's something you want to avoid. We're talking about keeping your assets in the bloodline instead of going to in-laws and their families. Very popular with our clients. And protecting your home and life savings from the extraordinarily high cost of long-term care. Today, over over 20,000 a month. So, the overall theme is we're going to keep control in your family and out of the court system. Something you want to do. I was a litigation attorney for more than 10 years, from 1980 to 1990 or so. And one of the main reasons I got involved in estate planning is because it keeps family out of the court system. Well, after spending 10 years in the court system, I had a very good understanding of why you'd want to stay out of there. So again, if you joined us late, thank you. We just got started. We're just on the overview. And as I said earlier, if you have questions, just type them in and we'll answer all those questions at the end. Thank you for joining. I'm Michael Ettinger, and we're going to proceed with the first of the 4 advantages of using trusts. And the first is trusts protect you from guardianship proceedings if you become disabled. Wills don't do that because wills only take effect at death. A guardianship is while you're living. So, as I say, a will takes effect on death. It's only for after you're gone. It doesn't address what happens if you become ill, homebound, or disabled. Eventually happens to half of all people. Whereas a trust is a plan for all three phases of your life. You run it now while you're healthy and competent. It says who takes over if you become ill or disabled, and then what happens to your assets after you pass. So we say, about half of all people will have a period during their lifetime where they can't handle their affairs. If you don't have a plan, New York State has written a plan for you. I'm sure most of us have heard of it. It's called guardianship proceedings. Now, you may think, well, my son or daughter has power of attorney. It's not going to be necessary. But surprising to most people, the courts in New York can override your power of attorney and appoint someone else as guardian. They can actually cancel it. How does this happen and why does it happen? Well, in my experience, it mostly happens with nursing home and their attorneys. Mom or dad is in a nursing home. The facility wants to make sure they're getting paid, especially because they're getting paid at the rate of 20,000 or more a month, and they want to secure that payment. And courts are sympathetic to the nursing home's position because they have the person there, they have all the responsibility, they have all the expenses, and so they want to be assured of payment. So the court will appoint an attorney for to represent the nursing home's interests, or a guardian, I should say, to represent the nursing home's interests, and the power of attorney is canceled. We certainly don't want that to happen. The essence of the problem is the court chooses who the legal guardian will be, and it may be, and often is, a stranger. Well, one of the major problems, and we saw this in the Britney Spears case, although it was a younger person, very difficult to get back control of a guardianship without a court order. You have to get a court order, but it's very hard to get it. These proceedings are expensive, tens of thousands of dollars, not unusual, time consuming, multiple court proceedings, and very stressful because you don't know how long it's going to take, you don't know how much it's going to cost, and you don't know who they're going to appoint. Now, let's say mom or dad needs care and a legal guardian is appointed. That guardian can't just take their assets and move it to the children for safekeeping or set up Medicaid trusts or do all the things you're allowed to do because they're subject to court supervision. So anything they want to do, they have to ask the judge for permission. Well, let me go back. I had a case a few years ago. I'll just try to explain it simply. A few years ago, I had a case where under the law, I could save about half the ill person's money by moving it to the children. You can do this actually on the nursing home doorstep. It has nothing to do with the 5-year look back. It has to do with another set of rules called the transfer rules and a strategy known as the gift and loan strategy. But the main point is I could save half by moving it to the children. Well, when the legal guardian is appointed, can't take half of mom or dad's money and move it to the children because the guardian can only use the money on the person they're guardian for. So I was fortunate. I got the guardian to apply to the judge for permission to move some of the family's assets for protection. And to my surprise, the judge turned down the application, denied the request, because the judge said, well, I believe it's mom's money and it should be used for mom, and if there's anything left, the children will get what's left. What happened there? Well, the family got the judge's values instead of the family's values. This is what the judge wanted, and the judge was in charge. So we don't want to be there. It's a total loss of control. So how do you avoid guardianship? Well, revocable living trusts do that because unlike a will, the trust takes effect while you're living, which is why they call it a living trust, and it stays in effect if and when you become disabled. Essentially what happens is a doctor puts in writing you're unable to handle your legal and financial affairs. Your successor trustees take over. But let's backtrack a bit. The trust is going to be in your name. You're going to name yourself as the trustee or the manager of the trust. And to get the assets into the trust have to be retitled because the trust only governs what's in it. So I'm going to prepare a new deed. I'll deed your house from you to the name of your trust. In this case, Mary Jones, trustee of the Mary Jones Living Trust, dated whatever the trust is, assist you in changing your bank accounts over, your investment accounts. Now everything says Mary, trustee of Mary Trust. Now, the trust is really quite neutral. You don't file a separate tax return. All the trust assets use your social security number. Everything's exactly the same as before. No restrictions, no limitations, just a different name, Mary, trustee of the Mary Trust. Nothing actually happens until Mary dies or if she becomes disabled. So let's look at that. So in the trust, Mary named her son Bobby the successor trustee, and Bobby would get a letter, in this case, from the doctor saying, Mom is unable to handle legal and financial affairs due to mental capacity limitations. Brings that to us. We prepare an affidavit saying Mom is incapacitated. Here's the doctor's letter. The trust says Bobby's the backup trustee. Please change the name on the assets to Bobby as trustee of the Mary Trust, and Bobby now runs the trust the same as Mary did before. But now the persons you know and trust are in control instead of legal guardian. Now this is a world of difference because what are the people you know and trust going to do? They're to come and see us here at Ettinger Law Firm. They're going to say, you set up my mom's trust 15, 18 years ago, whatever it is. Now mom's in a nursing facility. We're the trustees. What do we do now? And we take them through the host of options and they can pick the one that suits them best. But it's done privately in your own lawyer's office without the expense and delay of probate court, of guardianship proceedings. And they're going to do what's in your best interest. And it happens very quickly because it's just a matter of making an appointment and then executing the plan. Nice thing is people recover from disability. When you recover, you're not going to court asking a judge for permission to get your own assets back. You take back control from your family whenever you feel ready. Now, you recall a moment ago, I said the judge can cancel your power of attorney and appoint a legal guardian. Fortunately for all of us here today, the judge can't cancel your trust. The trust is more powerful than the guardianship proceeding, which means you are guaranteed to get the people you choose in the event of disability. I like to tell people you're really only as good as your backup plan. That's your control. By having a backup plan with your people in charge, can be one person, two people, they could act together independently, but it'll be your plan, your choice. So the first reason we use trust, avoid guardianship, keep control in the family, you have planning options. They're going to take care of you, the people you know and trust. What about the power of attorney? I like to say that not all powers of attorney are created equal. So you're going to want for your estate plan what we call the elder law power of attorney. Now, the standard form that most lawyers use, I call that over-the-counter medicine. This elder law power of attorney is prescription strength. And it works just like medicine. What happens if you have over-the-counter medicine, but you need prescription strength? Well, you know what happens? It doesn't work. It's not strong enough. And that's exactly the case here. The standard power of attorney that most lawyers use is not strong enough to address the problems that you have if you become disabled. And why is that? Because they're not elder law attorneys. They don't know what's missing from the form, and they don't know what to add to the form because they don't handle elder law. Elder law attorneys know what to do. And if you get a power of attorney from an elder law firm, it almost certainly will have the powers that you need, assuming it's a quality established firm. But we use this elder law power of attorney mostly to transfer and protect assets in the event of disability. So I'll give an example. We're going to talk about the unlimited gifting power. So on the nursing home doorstep, I can save at least half the assets by moving it to the children. But by moving it, I have to gift it, and it could be hundreds of thousands of dollars. Now, the standard form power of attorney allows your agent to make gifts up to $5,000 a year. Well, let's say you're on a nursing home and doorstep and you have 600,000. I could save 300,000 by moving to the children, but I need the unlimited gifting power to move 300,000. If I have the standard form, I can only move 3,000. I'm sorry, I can only move 5,000. So in 3 years, I'll have saved $15,000. The other 600,000 will be, virtually gone. So I could have saved 300,000 if I had the elder law power of attorney. I'm going to save 15,000 or 5,000 a year with the standard form. So really too weak to help us invent a disability. We're going to see a little later that by planning ahead, 5 years ahead of time, we can protect all the assets. The saving half is if you didn't plan ahead and you're on a nursing home doorstep, we can always still save half if we have this elder law power of attorney. So avoiding guardianship, very good. Have our elder law power of attorney. Now, the second reason why trusts are preferred over wills is because trusts protect you from the infamous probate court proceedings on death. Wills don't. Well, this is exactly the reason why I'm with you here today, because I was in litigation for 10 years, as I said earlier, and I had a lot of probate court proceedings, and they were expensive, they were time consuming. But the main thing is, I had no control over it. My clients wanted control. And I used to say, when you go to court, who's in charge? And of course, it's the judge. And does the judge always act in your best interest? No. Does the judge ever make a mistake? Of course. And when the judge says jump, your answer not only has to be how high, but actually how high, Your Honor. So I didn't like the fact that not only didn't I have control, but my clients had no control, and I had no answers to them. I couldn't tell them how much it would cost, how long it would take, when it would be resolved. Nobody wants to be in that situation. It's a total and utter lack of control. So the court has control. How long is it going to take? I don't know. Believe me, you don't want to be calling them and asking them because they don't really like that at all, and you don't want to get on their bad side. So the executor can't act until approved by the judge, can cause lengthy delays in getting access to money and other assets. It could take months, sometimes years. That money may be needed. You may not be able to sell a stock that's sinking or put the house on the market. Can you imagine carrying a house empty for a year or two? It can be a legal nightmare. These proceedings are often costly. They're certainly time consuming and again, stressful. There's nothing more stressful than uncertainty for people. How long is it going to take? How much is it going to cost? When's it going to happen? And meantime, bills are piling up. The house is falling into disrepair. It's vacant. You can't get insurance on it. All kinds of unpleasant things happen. Not only that, but the will is a public record. Anybody can go down and look up how much you had, who you left it to, who you left out. And not only that, but who are the heirs and where do they live are also in the probate court petition. So people want privacy. So let's look at the benefits of trust. Avoids probate court proceedings entirely for trust assets, saves time. We're talking, weeks or a couple of months instead of what could be many months or years. Legal fees, much less, obviously, with the trust because there's no court proceeding and you don't have to pay the court filing fees. Now, let's look at this in a little more detail. Avoids probate proceedings entirely for trust assets, which means you have to get your assets in the trust. Now, we've been doing this for 35 years, so we have tremendous experience in making sure the assets get in the trust. And I like to say that we care. I think we, care deeply that your trust works when you need it. So we put in significant time and effort in making sure the assets get into the trust. Now, I know I don't want to bash anybody. I'm not mentioning other firms, but not everybody takes this approach. Some firms will say, well, here's the trust. Go and put your assets in. Thank you very much. Well, we're going to assist you, but we're going to troubleshoot it. A lot of the work we do for you. If you have financial advisors, we ask you for the email address. we're going to send them an email, ask them to retitle the account. Of course, we'll copy you so you can approve, but we want to make sure the assets get in the trust. We're going to prepare all the deeds for you, so deeding your property to the trust we'll take care of. We'll give you paperwork to take to the bank. If you're going in person to the brokerage, we'll give you the paperwork to take in person. But again, we can do it by email. But I would say we are very effective and caring about getting the assets into the trust. Because again, if it's not in the trust and there's no joint owner or beneficiary, it's going to end up in the probate court. So if it's outside the trust, we're also careful to make sure that you have a beneficiary on that account. So if you die, it goes to them automatically, or you have a joint owner, automatically goes to joint owner. And it's probably because of my litigation background, I'm very bullish on avoiding probate court proceedings. But now you have control, your family has control, the court doesn't have control. This is an antiquated system. Nobody wants to give up control over all their assets and where they stand. So now upon death, the backup trustee can act immediately. By immediately, I mean maybe a couple of weeks, because they have to get the death certificate and we have to prepare an affidavit saying so-and-so died. Here's the death certificate. So-and-so is the new trustee. Here's a document saying they accept the trusteeship, they agree to act, and retitle the accounts to their name. And then next step, pass it to the heirs according to the terms of the trust. But no need for the court appointment. Just wonderful. I've been doing it, founded Ettinger Law Firm in 1991, so it's our 35th year. And I can't say enough about how much I enjoy creating trusts, working with them, settling them, essentially serving people and making them happy. These trusts are private. There's no public record. Nobody can look up how much you had, who you left it to, who you left out. Only your named heirs get to see it. So if you have an estranged heir or somebody who thinks they're entitled to more than you're giving them, they're not going to have any control over attacking this trust, because trusts are very, very hard to contest. Courts don't like to overturn a trust. They feel if somebody did a trust, they probably knew what they were doing. It's more sophisticated than a will. But the other thing is, when somebody contests a will, remember, it's already in court. So the judge says, stop everything. It's a freeze. There's a contest, and nothing moves until the contest is decided. Well, that could take years. So you know what happens with the will contest? The legitimate heirs end up settling because they can't get theirs unless they settle with the illegitimate heir. With the trust, remember, it's not in court. So now, if somebody wants to challenge the trust, the assets have already been distributed. It's like closing the barn door after the horses are gone. It's just too late. You'd have to run after all the heirs. Lawyers don't want to do that because it's much more difficult than a will. A will is already in court and the assets are frozen. But the trust, there's no such thing. So a trust is going to avoid a will contest. Not only that, but it's hard to contest when you don't know how much the person had, where it was, and who got it. So you have privacy. Let's talk about something called the multiple probate problem. Let's say you own this house in somewhere in New York and one of these pastel-colored condos in Florida. You have to probate in every state where you own property. Well, it's called the multiple probate problem. But fortunately, we can deed your property from any state into your trust here in New York. We'll avoid these multiple probates. A word to the wise here. So reason number 2, trusts protect you from probate court proceedings on death, save time and money and stress. Wills don't. We want to get that estate over with, distributed, and everybody go on their way. Reason number 3, trusts protect the inheritance you leave from your children's divorces, losses, and creditors. Keep your assets in the bloodline for your grandchildren. Wills don't do that. Well, this is the famous Inheritance Protection Trust, invented by yours truly in 2008. And we have done tens of thousands of these trusts. They're proprietary. We have written our own, and it suits our clients very well. Instead of leaving it to instead of leaving it to your son or daughter, you leave it to a trust for them. Okay, so you have 2 ways. You can leave it to the trust or to them directly. But you want to leave it to the trust, because if you leave it to son or daughter directly, and they die, it goes to your son-in-law or daughter-in-law and their family. So let's look at how to avoid that. So you have a son, Billy. Okay, so we name him the trustee, the Billy Trust, and we say on death, Billy's share goes to the Billy Trust. So it's Billy Trustee, the Billy Trust. And in the trust, it says, Billy, you can spend whatever you want. It's your money. We're not ruling from the grave. Buy, sell, trade, spend. You can spend the whole thing. There's no limitations on him. But because it's in a trust that you set up, it's called a third party trust, right? Set up by a third party, which is you. It's not him and his money. Third party trusts are protected if he gets divorced. What's the divorce rate? 50%. It's protected if he gets sued. People get sued for all kinds of things today. Or if he has financial problems, bankruptcy or creditors, sheltered from lawsuits and creditors. But it says, Billy, when you die, whatever you didn't spend goes to your children, others, my grandkids. What if he doesn't have children? Goes to his brother and sister. Passes by blood instead of by marriage, keeps your money and your family for generations to come. Right? So without the trust, Billy dies, goes to his wife, Mary. She gets remarried, and a stranger has all of your assets. I'll tell you a story. A number of years ago, I had a client, his last name was Schwartz. He came into my office in White Plains, and he introduced me to his fiance. Oh, very nice, Mr. Schwartz. Pleased to meet her. And then we sit down, and he wants to leave his estate, one half to his fiance, one half to his daughter. I say, fine. Very nice, Mr. Schwartz. I drafted it. At that time, we used to take a retainer check. You'll see we don't do it anymore, maybe partly because of Mr. Schwartz. But come back in 2 weeks. We'll have everything signed. We'll have everything ready to go. You can sign it. Well, he was, I think, 72. His fiance was 55. Next day after the first meeting, I get a call from his daughter. She says, my mother's turning over in a grave. All this money came from my mother. It was over $1 million, went to my father. Now, I've been his daughter for 50 years, and he meets this woman 6 weeks ago and wants to leave it half to her and half to me. This is outrageous. I said, well, I'm terribly sorry, but as long as he's legally competent, he could do whatever he wants. So the reason it's a funny story is because 2 weeks later, Mr. Schwartz comes in to sign the trust with his fiance and another woman. So I said, well, Mr. Schwartz, who's the other woman? He goes, oh, that's my lawyer. I said, really? I thought I was your lawyer. He said, well, a man can have two lawyers, can't he? I said, well, yes, he can, Mr. Schwartz, but not at this law firm. So at the time, I went to our bookkeeper and I said, how much did Mr. Schwartz pay us? She gave me a check. I went into reception. Here's your check. Thank you very much. Find out the next day, who was the other woman? She was actually the fiance's cousin, the lawyer, coming to make sure her 50% was nailed down tight. So there you go. We want to avoid this type of problem. You can also afford protection against the beneficiaries themselves. People have children who are spendthrifts, who are controlled by their spouse, and you don't want their spouse to control your money. They could be a soft touch. They could have a learning disability, special needs. They could have substance abuse problems, drugs, alcohol. So we may want to protect them against themselves by having somebody else as a trustee or co-trustee with them. It could be another family member. It could be the lawyer. There's pros and cons. It requires a discussion because, if you make the brother, sister the trustee and they say no, it could poison the relationship. So we have to talk about that in a consultation. But you start to see the value of the Inheritance Protection Trust. So we're going to dive a little deeper. I'm going to try to move myself out of the picture here. There we go. Here's our typical family. Grandma and grandpa, mom and dad, the three children. And now that's Billy and Mary. Let's say Billy is the son. When grandparents die, they leave everything to the Billy Trust. And if he dies, it goes to the children. Now, if he doesn't have children, I mentioned it goes back to the brothers and sisters, and nieces and nephews, passes by blood instead of by marriage. Now, many clients are quite fond of their son-in-law or daughter-in-law, Some of them are more fond of the daughter-in-law than their own son, in fact. It happens. So you could say, you may want to not want to do this. It's a young marriage, but let's say it's a mature marriage. You'll see we review it every 3 years, so you may want to add this later on. But let's say you want to take care of Mary. You could say, if Bobby dies, I said Billy, but I'm going to call him Bobby. If Bobby dies before Mary, and they're still married, and they're cohabitating, people could be married and living separate and apart. So we'll make sure they're living together as husband and wife. Give one half to the children at that time. Keep the other half in trust for Mary. Give her the income for life. And then when she dies, give the second half to the kids. This way, even if Mary does get remarried, husband number 2 doesn't get the money because it's in a trust, income to Mary for life, and on her death, back to your grandchildren. So you can do something for the son-in-law, daughter-in-law if you're so inclined, or you can add it later. But essentially what's happening here is your careful planning will continue for decades after you're gone. Very popular. And reason number 4, trusts protect your home and life savings from long-term care costs. Wills don't. So now we're going to get into the famous MAPT, Medicaid Asset Protection Trust. And I'll talk about the difference between revocable and irrevocable trusts here. So you place your home and money investments you want to protect into the MAPT, and this will qualify you for Medicaid for home care or for facility care. This trust has up 3 roadblocks that Medicaid cannot break through. It's irrevocable. Now, right away, people, when they hear the word irrevocable, they want to head for the hills. Irrevocable, I can't undo it. In fact, most lawyers think you can't undo it, but it's not correct. It's irrevocable because you, the person setting it up, or if you're a couple, the two of you, you cannot revoke it yourselves. So the law says, so far as you're concerned, that's an irrevocable trust. You can't undo it. But we have another rule on the books in New York, a very good rule in my view, that if everybody in the trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the parties, which is you and your adult children, not a problem. Later on, I'll look at, I'll explain why you can undo it even if one of them won't agree, there's a workaround. But the key to this trust, you can't be the trustee. Remember the trustee's the manager? Well, you can't be the trustee because if you're in charge, Medicaid will say, well, you can get it, take it out and give it to us. If you could get it, they could get it. So you're going to pick one or more of your adult children. And these are called income-only trusts because you agree to take only the income, interest on CDs, dividends on stocks. So let's look at who does these trusts and why they do it. Well, first, it doesn't affect your lifestyle because you still get all your income. You get your Social Security, your IRA distributions, your pensions, etc. All income from interest, dividends, all income from all sources stays the same. It makes sense for assets you're not going to spend, like your home. It's sure not going to make a difference to you if your home is in a trust, revocable, irrevocable, because the trust says you have exclusive right to live there, use and enjoy the property, you keep all your exemptions, the star, you want to sell the house, you have the same exclusion for the capital gains tax as if it was in your own name. What about investments you're only taking income from or you're just reinvesting? Well, why not protect the principal? Put in the trust. Otherwise, you're safekeeping it for the long-term care industry. Put in the trust and still there if you need it, but somebody else can't come and take it away from you. So you have the exclusive right to use and enjoy your home, called the life rights, life estate. Now, you have control over the trust by retaining the right to change the trustees at any time. And you also can change who you leave it to. So it's an irrevocable trust, but when you set it up, you reserve certain rights. One is to change who's in charge, and the other is to change who you leave it to. So remember I said you could revoke the trust on consent of all the named parties? What if one of them says, I don't agree? Not a problem, because you can change who's a trustee. You can fire them as trustee. You can take them out as a beneficiary, and they're no longer a party to the trust. You don't need their signature. All of which is to say, even though you put in an irrevocable trust, you still have complete control over that those assets and that trust and the people who are running it. So it's like having your cake and eat it too. Very few people know how flexible these trusts are. Accountants don't know it. Financial advisors don't know it. Lawyers don't know it. Only a handful of people, even in the elder law bar, not everybody knows it. There's a few lawyers. We're not the only one. There's a few good firms that know how to set up these trusts so you can change who's in charge. You can change who you leave it to. You can undo it at any time. No, it's completely flexible. I love it. When I first got wind of this 35 years ago, I said, this is like having your cake and eat it too. It's there if you need it. You don't want it, you can undo it. What could be better? So Medicaid only gets the income if you need care. The nest egg is protected for your children and grandchildren. So we're going to take a deeper dive into the trust. So the trust can sell the house. Trust sells the house, the money's paid to the trust. Trust goes out and buys a condo. Doesn't start the 5 years over again. It's done internally. Can buy and sell and trade stock. Now, maybe you're one of those people that likes to run your stock portfolio, but your son and daughter are on the trust, not a problem. They can sign what's called a third-party authorization with your financial people, whoever it is, Raymond James, Morgan Stanley, whoever you have, and they sign what's called a third-party authorization. My name's on the account, but I authorize mom or dad to make trades and you run the account. The other thing they could do, they can open an online account, take out a PIN, give you the PIN, and there you go. You go online and just put in the PIN and you run it yourself. We know there's a 5-year look back for facility care. For a number of years, there was a possibility of a new 2.5-year look back for home care, but it just has not passed. And we don't see it on the agenda for 2026. So there's no look back for home care. Isn't that great? Move your assets this month, apply for home care next month. Not a problem. Now, you can't take out principal from the trust because if you could get it, Medicaid could get it. But what if you need $50,000 because you want to take your whole family and your lawyer on a round the world trip? Thank you very much. You can't take the money out of the trust for that, but you can give a gift of $50,000 to your son or daughter. Because when I apply for Medicaid, I have to show them what you took out of your name and put into the trust. Fortunately, I don't have to show them what the trust gave to somebody else. So you give 50,000, you tell your son or daughter, take 50,000 from my trust and put it in your name. Now, can they give it back to you? No, because if we apply for Medicaid, I have to show them your bank accounts for the last 5 years. If they see 50,000 came in, they're going to say, where did that come from? And if it came from the trust, you're sunk. So they can't give it back to you, but they can spend it on you. They can pay for the trip or whatever else you tell them to pay for. So backdoor, make a gift to them a principal, they spend it on you. Fortunately for us, IRAs, 401ks, 403bs, TDAs, 457s, all these plans deferred to age 73 are exempt from Medicaid. Medicaid can't go after it except for the RMDs. What are those? Required minimum distributions. So you have to take out your X% a year, 4% or so, starting at age 73. You have to take it. That's income. And if you're on Medicaid, you get your income. But the nest egg is protected. And it's also protected from probate because, remember, it has a designated beneficiary. Now, let's say you don't know about that 5 years. Well, it pays to get started because if you don't make the 5 years, you only have to pay for the time left. For example, you set up the trust. 4 years later, you have to go into a nursing home. You only have to pay for 1 year. You already got 4. So it always pays to get started. So we started with the premise that estate planning with trusts creates order out of chaos. And how does it do that? Well, now we know. It avoids, any of these are chaos. Avoids guardianship on disability, no greater chaos than a guardianship proceeding. But it keeps control in the family, and your people will have asset protection options. Whatever they can save, they'll be able to save because they're in control. And they can come and see us and we can give them their options. It avoids probate death. Again, there's that word control. I mean, if I had to describe all of elder law estate planning in one word, the word would be control. What we're doing is we're keeping or taking back control. So now on death, control is in the family, saves significant time and money in settling estate, keeps your affairs private. Protects the inheritance you leave from children's divorces, losses, and creditors, then passes it by blood to your grandchildren instead of to your in-laws and their families. And finally, protects your home and life savings from long-term care costs, make you eligible for Medicaid benefits for home care or nursing home care when and if you need it. So I'd like to spend a couple minutes on our unique planning process. Here's a copy of my new book, my third book on this subject. We call it Ettinger Law Firm's Guide to Protecting Your Future. And it's about 300 pages, but it's easy to read print, and it's very concise. And we will assist you with what you should know from the book. So our process has begun with this seminar. You're already warmed up. This is a terrific start because we're starting to build your confidence. You know, I believe that to have an effective estate plan, we have to build the client's confidence. Now, for you who are listening, everyone who comes to see us is in low confidence. And that's because they don't know the subject. They are afraid of looking silly. They're afraid of being intimidated or not understanding. There's a lot of fears, and I understand that. So we consider it our sacred obligation to build your confidence so you understand what you're doing and you feel comfortable with it. I have an expression I'll share with you. I like to say, if you don't understand the plan, you don't have a plan. So we're going to make sure you understand it, not only for yourselves, but you can be able to explain it to anybody else that you wanted to. So we're going to offer you a no-cost initial consultation, very low-key at Ettinger Law Firm. We're going to do a complimentary review of your existing plan, all your documents, and I will point out where they're deficient and why, so you'll be able to understand it. It's very common for them to be deficient because they weren't prepared by an elder law firm, and now you need more powers, or the power of attorney was very often done incorrectly. All kinds of issues that these are often done by general lawyers. They don't have the level of expertise, but we'll point everything out. And when I talk to people, I go over the things like this. They say, "Well, that makes sense. That makes sense." People understand it, and it makes sense to them. We're going to give you a free copy of my book, Ettinger Law Firm's Guide to Protecting Your Future. We'll tell you which chapters apply to you. It's plain English. We'll ask you to read it. We'll tell you right in the first meeting, based on what we see in our assessment, this will be your fees, because everybody wants to know. That's okay. Then we're going to ask you to come in for a second no-cost follow-up consultation to answer questions about what you read in the book and anything that arose out of the first meeting. So now you come in for your second consultation. As I say, we answer the questions. We draft the estate plan together with you. What does that mean? Well, we start to get your input. Who do you want to make medical decisions? First choice, second choice. Who do you want to handle your legal and financial affairs? One person or more than one person? How do you want the plan distributed? All at once or over time? And are there any special issues, like somebody needs to have a trust continue for them managed by somebody else? Do you want to pay it out all at once over a period of years? A lot of things to discuss, and we get your input, and we draft the estate plan with you, and then we give you a detailed written proposal for the fees quoted. So there's no fees at this meeting. We're exploring, we're drafting the plan, we're preparing the proposal and giving it to you and going over it with it, and then at the end of the day, the choice to go ahead is yours. We don't have a retainer agreement for you to sign. So remember with Schwartz, I got a retainer, but that's many years ago. For many years now, I believe we're the only firm in the country in the field that does not take a retainer. So the retainer is universal. This is the way every estate lawyer is trained. Client wants to go ahead, you have them sign the agreement, they give you a check for half, and the other half when they come in and sign. And I took that as gospel for many, many years until I analyzed it myself, and I realized that was not the best way to do it, and here's why. I'm all about putting you in control. You're the client, you want control over your affairs. Now, one day I realized, I'm giving this seminar and talking about control, and then the first thing I'm doing when the client comes into the office, because I'm doing it the way every other lawyer does it without a question, is ask a check for half the fee. But what I'm doing really, or what the other lawyers are doing, is they're taking away control, because when you give the lawyer that check, what do you have? You have nothing. You just have actually, you have less than nothing. You have a loss of control because you paid money for a promise. You have to hope that the lawyer performs. I have to hope the lawyer performs to your satisfaction. That doesn't make sense. That's not the best thing for you. So what we figured out that was the best thing for you is for us to uh, uh, prepare the documents on your say-so. You don't sign anything, actually. We give you the agreement, but we sign it. You don't sign it. Our agreement says, come in, we'll go over all the documents a third time, and after you sign, your payment is due, but you have no obligation unless and until you sign that check. So until you sign the check, you're in control. Well, doesn't that sound good for you? It is good for you. And what we figured out at Ettinger Law Firm is, if that's the best thing for you, and we're here to serve you, then it must be the best thing for us. So we've done that for maybe 10 years now, and it's just wonderful. We only have happy clients here because nobody pays us unless they are happy. And we go to great lengths to make sure you are happy. That's our job. We're here to serve. So it's best for everybody involved. Um, so you come into the final meeting, we review and sign the documents, and now we accept credit cards, but there's 3% charge. People don't like it anymore, so they usually give us checks. You can pay it all at once, or you can do three equal monthly payments. That helps people who are paying out of cash flow. Some people are paying out of their income. So now we don't say goodbye. We say welcome. Now, the standard in New York, amazingly, is thank you very much, goodbye. In fact, this is what the bar advocates. The bar says we should send you a letter after we're done saying thank you very much for your patronage. This concludes our representation of you in this matter. And they tell that to us because this way, if we made a mistake, the statute of limitations runs from the date of that letter, and after a few years, you won't be able to sue us. Well, who's that good for? The lawyer, right? And that's because the way lawyers are trained and the way the bar thinks about it, the lawyers are concerned about the 1 in 10,000 clients who's going to sue them. We're actually more concerned about the 9,999 that aren't going to sue us. So we don't say goodbye. We don't believe in that. What the bar is saying, and I just don't agree with it, they're saying it's a transaction. Thank you very much, goodbye. It's not a transaction. It's the beginning of a relationship. You're estate planning lawyers. You need to be able to count on us. So I trademarked the process back in '91, where we keep you up to date of law changes and other matters through our. We won an award for this actually weekly. Ettinger Elder eAlert. We call it the eAlert because it comes by email. Been publishing that for many, many years. And we call you in for a free review every 3 years because we want the plan to work. So we want to see if there's any change in your health, assets, family, anything else. It's a checkup, just like you go to the dentist. We don't charge for phone calls, emails, or questions. Why? Because we want the door to be open. We want you to communicate with us. I'll tell you, as I tell clients all the time, it's no bother. Call us anytime. That's what we're there for. And so not only do you get the answers you need when you need them, but for heaven's sakes, you get the correct answers, which is hard to get these days. Some of you know I publish a column in 13 newspapers. I've been published my 4th year publishing it. And I published a column last year entitled, When It Comes to Elder Law, There's More Misinformation Than Information. You go and study it on the internet, there's more incorrect information than correct. So get it from the horse's mouth. That's why I wrote the book, because the book is in the public domain. It's on Amazon. All the lawyers read it. Nobody's found a mistake in it. So you have something that's definitive there. The point is, by using this program, your plan is never more than 3 years old, designed to work when you need it, hopefully many decades from now, not when you signed it, as I say, decades earlier. So how do you get your no-cost consultation with me or Suzanne Ettinger, my wife and law partner, or one of our experienced? All the elder law attorneys at the firm, they're trained the same. They're excellent. I'm an expression. I say we hire for character and we fire for character. We only have the best people. And if you get the opportunity to interact with us, you'll see that for yourself. So You'll have it with me or Suzanne or one of our other elder law estate planning attorneys. You can insist on me if you like. That's your prerogative. You get to pick the lawyer you want. But the consultations are in office, by video, by phone. I do them on Zoom. I do them by phone. They're not as good as the office. You don't get what you get by meeting in person, but it's up to you. Not everybody can come or they can't fit in their schedule. They're working. We're flexible. But sooner or later, if not the first meeting, the second or third, you'll have to come to the office. But we'll get started. Just call the 800 number or visit us at trustlaw.com. Very easy. Schedule the consultation. We're very low key. I'm very proud of the fact, not only myself, but all of our lawyers, if you don't need it, we'll tell you. If you should wait, we'll tell you. If you can do something less expensive, we'll tell you. That's how we practice. I turn away any number of people in a given week because I'll explain to them it's not worth the money for you. People come in all the time and say, I want to trust, I want to trust, I want to trust. Then I analyze, say, it's not worth the money. Do this instead, or wait until this, But we don't do something and don't recommend it unless it's worth much more than it costs. If it's not worth what it costs, we're not interested in doing it. Even if the client wants us to do it, if we don't feel it's worth it, we just won't do it. We'll say, well, it's not for us. We don't do work that we don't think is worth it for you. It's a value proposition. So I'm going to stop the share. Let's stop the share. And we have a few questions. You can add to them, but let's answer the questions that were typed, and then we will go into the questions that were sent in. But Chris asks, mother has home health aides, worried she's becoming cognitively impaired. Certainly happens a lot, losing her sight. If she becomes more disabled, we won't be able to afford the help. She gets $50,000 a year in pension and Social Security. Should we think about getting a pooled income trust to protect her assets? Yes. Can I explain how it works? Well, briefly, when you want to stay home, you're able to shelter the amount of income that you need to keep the home running. So all your bills get sent to the pooled income trust, and whatever income you send to them to pay those bills is protected from Medicaid. This is a system designed to allow a person to stay in their own home by sheltering their income, getting their bills paid so they can stay in their own home. We'll apply for Medicaid for mom. They will come to the house. They will prepare a document called a patient review instrument. Will determine her needs and how many hours they will award. And you should be there advocating, saying, well, mom needs help with this. She can't do this. Mom's not going to advocate for herself, especially if she's cognitively impaired, but you'll do the advocating for her, saying what she needs. They'll make an award, and that can be adjusted from time to time as needs increase. So we'll be happy to help with that, Chris. Anonymous, I'm interested in knowing whether my income from Social Security and annuity, which I receive now on a monthly basis, is affected. It's not affected. If you set up the Medicaid trust, you still get all your income. If you need care, the income at home, we shelter the income with the pooled income trust. If it's in a facility, all your income goes to the facility. Okay. Next question, Rebecca, what is a look-back period? You set up the trust, the Medicaid trust, you're not eligible for facility care, nursing home care, until after 5 years has passed. But it prorates, as I said earlier. Anonymous, can nursing home come after 401k, 403b, after one passes away? There is no right of recovery from a trust or from something that has a beneficiary. They only have a right of recovery from a will, probate, which is another reason to avoid probate. Marcy asks, what are the implications if you and your spouse have long-term health insurance? The implication is you're not likely to need the Medicaid Asset Protection Trust. You're a candidate for the Revocable Living Trust and perhaps Inheritance Protection Trust for your children. Anonymous, where can I find past newspaper articles in the Journal News? They're all on my website, hundreds and hundreds of them. So just go in. You should be able to find it without difficulty on the website. Anonymous, I've set up an MAPT with you. Thank you. Can I use my daughter's credit card to charge for my expenses like my needs and vacations, and she pays for it? The bill's under her name. Well, No, you can't use principal from that trust. What you can do is have her take the money uh, and use her credit card. So it goes from you to her account, you use her credit card, and you do it that way. If you like, we can talk about it more. Can she charge her credit card for my expenses? Yes, yes, she can charge her credit card for expenses and get reimbursed from the trust because anything for the trust to her doesn't show up. Should I convert my traditional IRA to a Roth IRA? Um, well, that's a financial advisor question. I'm not a financial advisor or an accountant. I'm not qualified to answer that. But you don't put a Roth IRA into the irrevocable trust um, because that would be the end of the Roth. It stays there, but we can protect it from Medicaid because it is an IRA and it avoids probate. Charlie asks, if the nursing home, Medicaid can only get income that's in the trust, what if you're receiving money from some sort of employment? Well, if you're in a nursing home or receiving home care, it's extremely unlikely you're employed, so you wouldn't have that income. But any income from all sources, let's say you're getting paid out, sale of a business or whatever, it's all available for your care. Ivy, can you put a house in a trust that has a mortgage? Yes, not a problem. You can put a house into an irrevocable trust that has a mortgage. Um, Marion, does the attorney I choose affect the cost? Well, you know, um, of course, attorneys are free to choose as they wish. Um, but, I tell people, uh, not a good idea to pick your brain surgeon or your heart surgeon or your estate planning lawyer based on cost. I think you want to go with competency because the cost will be long forgotten when you don't have the best lawyer or you have a less than the best because something goes wrong. You won't be thrilled that you saved a few dollars. It's really everybody's within a range, the best lawyers and the worst lawyers are not really that far apart. So, use your judgment on that. Um, Anonymous, can you incorporate an inheritance protection trust and a Medicaid asset protection trust as one trust? No, it's two trusts. The Medicaid trust for you, the inheritance protection trust for son or daughter. So your son is Bobby Jones. It says the Bobby Jones Trust. So he goes forward with his life, with his trust, with his terms, with his name on it, etc. It just works much better. We don't want to keep your trust going for his lifetime with your name on it, 50 years after you're gone. Anonymous, can co-op shares be put into trust? You have to ask the managing agents. About half of them allow it, so hopefully you're one of them. Do you have to pay off the mortgage? Yes, you have to pay off the mortgage. Now, some banks will allow you to put into a trust. Depends on the bank. So I take it back. Ask your bank if they permit a transfer of the co-op shares into the trust, and if so, we can work with the bank. Generally, what is the minimum net worth of people in order to determine if a trust is worthwhile? Well, the answer to that is not necessarily a minimum net worth, but let's say you own a house. If that's your only asset, well, then you want to have a Medicaid trust because you're going to end up losing that house if you need long-term care. So it's not a matter of minimum net worth because uh, maybe instead of a trust, you might do a will. Sometimes we do wills, or you're certainly going to need power of attorney, health proxy. Don't be afraid to come in. We don't judge people on what they have. It doesn't matter to us. We judge them on what they need, and we try to fill those needs. So you have some needs regardless. Let's talk about it. It's very low key. Norma, please clarify, if one parent has a long-term care policy, how exactly is that protected, including as parent-activated claims payment presently? Um, well, long-term care policy is not really protected. It's available to pay for you instead of your assets. Your assets are protected because you have a form of payment. If you have more questions as we go along, you can certainly add them. I'm going to quickly answer the ones that were sent in. If property is an irrevocable trust, can you sell it? Yes. What happens is the trust sells the house, money's paid to the trust buys the condo, doesn't start the 5 years over again. That was Galena. How to change the trustee? You come into us and we prepare a document to do it, nothing to it. Cassandra says, when you pass away, do the contents of the trust remain in the trust? No. The trust says where they go after you're gone, and it's the duty of the trustee to follow the terms of the trust. So the trust doesn't cease to be on death. It ceases to be when the assets are all distributed out of it. Michael says, I have a will which states on my death, after the death of my wife and myself, our total estate will be divided by the people named and a scholarship. Will this work? I honestly, I don't see why not. I really don't see what the problem is. So the answer is yes. While I'm talking, we have a couple of more questions came in from our listeners this evening. Anonymous, similar to what is the minimum asset level you think is important to have a Medicaid trust? Can you give given the fee you charge, what is a reasonable a percentage of the assets? We don't charge a percent of the assets. We charge all flat fees, maybe, in the range of 6,000 to 8,500 for a trust, maybe 9,500 if the trust has if the couple has a taxable estate and they need two trusts. Inheritance trusts, maybe 1,500 for each of the children, something like that. Anonymous, if I set up a trust in New York for my New York real estate, but ultimately end up living in Florida with my daughter, does the trust still continue? Absolutely. It doesn't matter where you live, the trust still continues. Let's see. We talked about the co-op, and you can put the co-op, and you got to call JP Morgan Chase and ask them if they'll permit a transfer to a revocable trust. Not an irrevocable, that's a no, but a revocable probably. We talked about costs. Here's Diana is asking you, what's the best sequence? I'm forming a nonprofit, putting land into a conservation easement, preparing a revocable trust. It's too complicated to go over this evening here, Diana. I asked you to come in to discuss that. If you put your house in the trust and you move out of state, you still keep the house in New York and the trust valid? Yes, yep. Thank you, Marie. We got that. If you have an S corporation, we put the stock into the trust, but we have to add terms to the trust to allow it to own the stock. It's called the Qualified Subchapter S Trust, QSST. We do that. Is it best to include a financial planner as a trustee when your beneficiaries have not demonstrated good financial management skills? A financial planner cannot be a trustee. It's a conflict of interest. They're not allowed to do it. So in that case, you would use Doris. You use the attorney as the trustee if you need that. And then the attorney works with your financial advisor. Okay. Patrick and Patrick, long time no see. Very nice man. One of our favorite clients. Opened a trust with us 6 years ago. He was in 3 years for a free consultation. Should I come in for another free consultation? It's been 3 years since the last one. Absolutely, Patrick. We're building relationship here, and we can't build a relationship unless we see each other. There's no charge. We want to see you, catch up, and of course, we'll tweak it and see if anything else needs to be updated. Always good to see you. Please come in. Now, somebody wrote in, Nancy wrote in, is assisted living treated the same as a nursing home? No, assisted living is not paid for Medicaid. Assisted living, your private pay, you're on your own. Susan, I have one child. His wife won't give him children. I'm sorry about that, Susan. She's 12 years younger than him. How to be sure the inheritance lasts his lifetime, that my daughter-in-law does not get full control on inherited money? How can the inheritance come back to my family, nieces, nephews? That's the Inheritance Protection Trust. We'll talk about that when we see you. Let's see. Somebody has asked, Bradley has asked about them. I'm not sure if the name is Perry or Bradley, but two first names, hard to tell. I think it's Bradley. How to mitigate the New York estate tax cliff. So if your estate is this year, if it's over 7.3 million, they tax the whole estate. There are a number of ways to avoid the cliff. One is to give the money away while you're living. We can help you with that, set up trust for your kids. But the other is something called the Santa Clause. I'll talk to you about that in more detail, but you say, I give the amount over the estate tax limit to charities, these charities in equal shares, and the charities come off the top so that you don't have a taxable estate. Yes, the trust can sell one house and buy the other. Jack wants to know about a spendthrift trust. A spendthrift trust is protecting children who are Spendthrift, we can do that, not a problem. Question of who will be the trustee, we'll talk about that when we see you. Carol, is interest from investments that are in a trust taxed at a higher rate than those not in the trust? Well, the answer is kind of yes and no. If you leave the money in the trust, it's taxed at the trust, but you have to take it out. So whatever you take out gets taxed at your individual rate. So the answer is if you take it out, you get taxed at your individual rate. Patricia says, what's the best way to set up a trust for the primary residence for children and grandchildren, but leaves it open to sell if we decide to downsize? As I said, the trust can sell the house, it's not a problem. Charlie, what do you put into a trust? Can I put my SSI and pension in a trust and still be able to see monthly payments? No, you can't put income into a trust. Income keeps coming in. You can only take assets, which you can retitle out of your name into the trust. So the trust protects assets, not income. Judith, do I continue to receive the income I'm getting from my annuity and Social Security when the trust is established? Yes, not a problem. Ivelina says, duties of the trustee and/or executor of the estate to distribute assets to the beneficiary. They have a fiduciary duty, a very high duty. They're personally liable for not fulfilling it. So generally, we don't have a problem. People follow the trust and do what they're required to do. Anne Marie says, can a house in New York have a statement on the deed that says transfer on death to our children? Yes, we have a new statute, 2 years old, that allows you to name a beneficiary on your deed. They had it in Florida for many years. It's called the transfer on death deed in New York. Florida, it's called the Lady Bird deed after Lady Bird Johnson. Yes, it avoids probate. It avoids capital gains taxes, but there's issues. You know, if you have 3 children and they own the house together, they might be fighting over selling it, how much they're getting for it. One wants to keep it, one wants to stay there. They argue about everything. I'd rather have it in a trust where you have one person in charge and they sell the house, and you don't have an argument about this, that, or the other thing. And then a late one was Yvette, who wrote How Much Do You Charge? Which we only charge flat fees, and it has nothing to do with the size of the estate. It only has to do with the assets you have. And we have a fee schedule, so it doesn't depend on your assets. So that is about it. Let's see if anybody else typed a question. Well, yeah, naturally. Charlie, do trusts protect the assets against a loss as a result of an injury? An automobile example, yes. This is why, Charlie, we don't put cars into the trust, so that if you have an accident, the assets in the trust are protected. If you put the car in the trust, then you'd have a problem with that. Anonymous, not a question, but an amazing seminar. They're very nice of you. Best I've seen. I'm convinced. Would like my husband, daughter, and sister to see this seminar. So, well, you're going to get a video of this seminar. Everybody who's here tonight gets a copy of the seminar, so they can watch this one. And the next one, it's always on the website. You can go and see. And I'll look forward to seeing you. Thank you. It's very kind. Charlie, what if the car is in the trust? No, we don't do that. We don't put the car in the trust for that very reason. It's a no-no. So I'm going to call it an evening. Thank you all for joining. Wish you all the best for 2026 and hope to see you all very soon. Thank you for coming and have a nice evening.